Good evening, everybody. My name is Ketan, and I really want to, first of all, thank you all for joining into the session today at a very short notice. There's a reason why this notice was very short, why I was moved kind of to, arrange this session and ASAP. This week, early this week, I had a client come into our office and she wanted legal opinion. She had come some, I think, 4 or 6 months back also. And it quite apparently looked like, there was a financial distress that she was going through. I didn't want to, of course, get into the details. And then early this week, she walked in and she's like, I have managed to sell my flat and I've got a buyer. Now I need to make a sale deed, which is what generally people go to a lawyer for. That is why she had come to us also. Now, when I looked into the documents for the sale deed, she was the seller, but it wasn't her name; it was her husband's name on the index too, on the documents. So I was like, fine. I mean, I would need your KYC documents, but not yours, your husband's, because he would be the one who would be executing the deed. And to my horror, she said, my husband has passed away somewhere last year. And he died due to COVID. In fact, that is why I'm doing all of this. Now, I couldn't even settle into this, I couldn't even complete my condolence. And immediately it struck me that there is something more in store here. Now, I wanted to help this lady. So I asked, like, did your husband make a will? Like, no. Now, she has a buyer. In this market, we all know how difficult it is to get a buyer in the first place. Now, currently, because of COVID and the pandemic situation, she got a buyer. That too after 4 or 5 months of trying. Now they're sitting in our office, and because of one document, she cannot make this. She cannot make this deal. She cannot go and execute the sale deed. The other document that would be needed, a succession certificate, an heirship certificate, that is at least going to take, at least even if we do the best of our the job to the best of our abilities, it's going to take 6 to 7 months. And of course, the buyer with the noblest of intentions, but why would somebody wait for 6 to 7 months? She had a son. I wanted to help her, but there is no way I could have helped her. And that day, that evening, it stuck to me as in, such a simple thing. Now, of course, I understand that the husband, she was youngish, she was 38ish. So must be the husband would be around 38, 40, 42, I assume. You never think in that age that, something like this is going to happen to you. Why would you? Of course. But that did stuck me. I mean, generally we youngsters, especially, I'm calling myself young here, but we people generally assume that, firstly, there is a taboo. I looked into the statistics. Only less than 2% people in India actually execute a will in their lifetime. Pretty staggering. And even in this 2% that I couldn't get a statistic, but I assume fairly that a huge chunk of it are people who are at least above 50. This needs to change. That is why this story, this incident moved me. And I discussed with my team and I said, no, we can't wait. Fine, as many people come, but we have to do this. We have to let people know that a will is an important instrument. Ladies and gentlemen, welcome to this session. My name is Ketan. I'm going to share my screen. Just give me one moment. Can you all see the screen?
Yes.
Okay. So as the session was titled in our promos, why, what, and how of making a will, I thought somehow there could probably be uh, a lack of awareness when it comes to making a will. You see, probably a lot of people would not know. This lack of awareness could also lead into ignorance. So that's why, what are the main questions that somebody could come up with while discussing a will is why make it, or what is a will, or what is the process, or how to make it. Right? So we're going to cover all of these things. Before we go ahead, a little introduction about us, about the company. As I've already said, my name is Advocate Ketan Heda. We like to call ourselves advocates. I've done my bachelor's in law from Pune University. I've also studied business strategy from IIM Bangalore. Um, this firm, by the way, was started by my father. He was a lawyer also. Unfortunately, last year I lost him. So this firm was started in 1989. We had our humble beginnings, and now we are growing in Pune since 2019. Right? Um, we have a very young, enthusiastic, energetic team. So we kind of are making a blend of experience and enthusiasm at the same time. All of these people are in this session, so maybe they could talk to you. I am right now residing in Switzerland. So I'll be back in India next month. But right now, even if there is something that you need to talk to in person, these three are always there in Pune. Okay, so as discussed, the agenda of the session: why, what, and how. First, let's start with why make a will. The first point is a will helps you differentiate beneficiaries from heirs. Now, this might sound a little technical. It is technical. Heirs, people who are according to the succession laws, um, heirs are people who are related to you, people who are in your heirship line, bloodline, as we commonly refer to it as. Now, it might well happen that there could be a lot of people in your bloodline, but your self earned property, you do not want to share it with anybody and everybody. It could be. You probably might want to just leave it with direct heirs, direct successors, or someone in particular, right? So, in through a will, you would be able to differentiate beneficiaries of your property from the heirs of your property. Secondly, it saves time and money. Now, for those of you who've joined late, I shared an incident. I'm not going to repeat it, but let me tell you what happens when you do not make a will, or someone doesn't make a will and unfortunately passes away. In that case, there is something called as an heirship certificate or a succession certificate, depending on what type of property you have, if you have an immovable one or a movable one. So depending on that, you will have to apply, you will have to file a petition for succession certificate. The process itself takes 4 to 6 months at least, right? And considering the load on judiciary right now because of COVID and even otherwise, it is taking a lot of time. Primarily, the process. I'll just in a nutshell tell you what happens when you apply for a heirship certificate. The court looks at the petition and then gives a notice in newspaper that such and such people, such a person has died, this is his property, and such people have come to us and they've said that we are the heirs and we should get the property. If anybody has an objection, please reach out to us within 45 days. 45 days is a stalemate anyway, considering nobody comes, right? Um, so, uh, there's a lot of time. It's also a costly affair because whatever properties you're claiming, you have to pay a stamp duty, a court stamp fee, according to the amount of property you're claiming, right? So it's your own property, and yet you have to pay stamp duty. So it's expensive, it's time consuming, it's a lot of hassles. Also, you would definitely need somebody to do it for you, like a lawyer, right? There would be a fee involved for those agencies also. Thirdly, A will would protect your family from uncertainties, protect your family from disputes. Right? You don't want to be a reason, your property being a reason for further disputes. And I'm sure it's common knowledge in India how property can lead to disputes, right? Fourthly, it helps in role defining. Now, what do I mean by role defining? In a will, you can actually name the person who is going to execute your will, or who is going to manage your property, right? So sometimes this is not very common. Generally, it's the other way. People come with disputes that I want the property, I want the property. But sometimes, if the property is not too much, right? And then the heirs are too many. Sometimes the heir tend to think the all of the heirs, they tend to think that, why for such a little gain, why should I put in so much of an effort? And nobody does what they're supposed to, or what they should be doing. If you write down who amongst these people is going to be the executor of the will, or the administrator of the property, manager, whatever, it becomes very clear, right? Um, the extension of this point is the fifth point: enforce your wish, right? It's your property. You might have a wish. I'm sure most of you would have a wish that this is my hard-earned property, and it should meet the final objective. It should land in the hands that I wanted to land in. If that is the case, a will is the only instrument by which you would be able to enforce your wish. If you die, I repeat for the ones who've joined later, if someone dies intestate without making a will, the term is intestate. So if you die intestate, succession laws apply to your property. And succession laws are pretty diverse, pretty complex. In fact, I might have to do one more session to explain succession law. I mean, if somebody is interested, we can talk about that. But yeah, succession laws are very, very diverse. They're not common. They're not uniform. They are different according to religions in India. They are different according to personal laws of India, protecting those religions, right? So will is the only way you can ensure that your wish is enforced even after you are gone. And one of the most understated purposes of a will is the last point. You are actually, I mean, some of you who are in the age bracket where your children are not yet adults, they're not yet above 18. For those people, we always are worried, right? I mean, of course, nobody expects that something wrong happens to you, to us. But at the same time, we have to admit that life is uncertain, and such is the nature of life, right? If something, God forbid, is to happen to you, forget about your property. Who takes care of your children who are minor? Because in India, a lot of things minors can't do. Law doesn't permit them, right? So it's your property, but he can't sell. It's his property now, but he can't sell. He won't even know. So you would definitely want a guardian until he reaches adulthood. Through a will, you can actually document a guardian, right? I think this is one purpose that most youngsters should, most new parents should take cognizance of. That for this alone, I think making a will is a good enough reason. Okay. So now from the why, let us move to what's of a will. But before we talk about what a will is and how and what about, let us see what a will is not. A will is not a contract or an agreement. Now, what do I mean? This could get a little more technical. A contract or an agreement is essentially between two or more parties, right? A contract is between two people. So there's a separate law, Indian Contract Act, governing contracts and agreements, right? They are also registered. Will could be registered. Will is also document. Agreements and contracts are also documented. But This is not a agreement. It is in fact a declaration. Right? This is very important because a lot of your questions would be answered in this will. We're going to see that later into this slide. Now, it's not a contract; it's a declaration. It is you declaring to the world what happens when you pass away. Yeah, it's not a contract. There is no exchange of money. There is no exchange of money for something. It's just a declaration. It is unilateral in nature. Types of will: testamentary trust, not very common in India. This is generally done by people who have, firstly, a lot of property, and secondly, a lot of beneficiaries. Some of them, or most of them, minors either, or most of them, they don't trust that they would do justice to their property. This is generally done by, for example, this is just an example. This is generally done by a business person who has a huge company, who has people in the company working for him for a long time, and now he doesn't trust his children to have the same humanitarian approach within their business. He might think that if after my death, my son, if he becomes the owner of the company, he might fire a few people, or he might have a different way, inhumanitarian way of handling things. So he wants to give him limited rights. He wants to ensure that he gets the property, but with limited rights. So this is very complex. Testamentary trust itself is very complex, right? And that's why less are done. Secondly, a joint trust. This is generally when couples, spouses, they make a will together. The problem with this will is it will take effect after one of the person passes away. I mean, in the sense, it cannot be altered anymore after one of the person passes away, but it will take effect only after both of them pass away. So God forbid, if you're making a joint will with your spouse, one of you passes away, and if there is a lifespan, of a few years, and then there are changes that happen in the way you think, the way you want, the way you see life. It is pretty much possible. In that case, you cannot do anything about this will, a joint will, right? Third type, contingent will, very rarely used. It is contingent, conditional. It's a will that the terms of which will be executed if and when some of the conditions happen, right? We strictly advise you don't do contingent wills, because somehow there is a lot of likelihood that in spite of making a will, the condition itself could be challenged, right? So a contingent will, but yeah, it exists. That's why I had to bring it up in the presentation. Fourth is a privileged will. This is for people who are employed with the army, with the armed forces, basically, or who are on national duty, who have a chance of dying, let's say, in something like a warfare, right? So those people, there was a time in the older movies we would have seen this, that deathbed declaration becomes a will. It was, in a way, it is still. But somehow there is a lot of challenge that happens after making such a will. So that's why such type of wills are now allowed only for the privileged people, like the ones I mentioned. Because if they are in a war, they probably might not get opportunity to make a will, and then they can make a will. This will can be made without witnesses also. And lastly, simple will, the normally done will, which is mostly what we're going to talk about today. How? Did I miss something? No. Okay. How? In the how part, first let us look at the process. What is the process of making a will? Firstly, collect all details. When we say collect all details, make a mental note or a note somewhere of all your properties, your movable properties, your immovable properties. Movable properties are things like bank accounts, gold, vehicles, whatever can be moved. Immovable properties, property, land, real estate. Um, there could be another set of properties which is intangible properties. I'm sorry, I forgot mentioning that. Intangible properties could be things like copyrights, patents, or if you are an author, your book. So maybe you would want to write what happens with the proceeds from your book, things like that. Secondly, then make a draft. There is only one condition about making a draft. It should be clear, unambiguous. People reading that will after you're gone should be able to clearly know what you meant. Do not use ambiguous language, simply because if there is an ambiguity, the only way to clear it is clarify with the person who wrote it, which for obvious reasons cannot be done, right? So our advice is meet a lawyer who would know what it means to be clear and unambiguous, discuss the scenarios, anticipate what you're thinking can go wrong, tell him all that, and then draft a will. Thirdly, get a health certificate. This is a compulsion because it's one of the necessary conditions that you need to be of a sound mind, and you need to be healthy while making a will. So get a health certificate from a registered medical practitioner, somebody like an MBBS or an MD. Right? No two witnesses. This is very important. It's a must to have two witnesses. And by two witnesses, I mean not just to sign on the draft. These witnesses would also have to come with you while you execute the will. Lastly, if you want to make a notarized will, or if you want to register accordingly, you need to go take an appointment and go to the notary or to the registrar. If you cannot really go to the notary, if you want to make a notarized will and you cannot go, if you are in some health condition or for any reason, if you can't go, you can take an appointment. There are a few notaries we know who do actually come with their setup to your place and get the will done. If it has to be a registered will, there is no way you can not go to the registrar office. That's the only way. So take an appointment, do the data entry, and get into the registrar office on the prescribed time. Go register it with the witnesses. Now, the format. Somebody had mentioned in the what would you like us to cover section that I want to know the format of a simple will, and I'm sure everybody wants to know that. First things first, there is no strict format prescribed by the law when it comes to making a will. Right? What I have done here is made components of will. What we think, what we advise, makes a will unambiguous, clear. All of the things that we discussed in the last slide. If we follow this kind of a format, or at least ensure that all of these components come into the will, that makes a wholesome, complete, understandable will. First is identity details. If you're making a will, key in your details, your name, your Aadhaar card, your PAN card, your address, the fact that whatever your age was while making the will, your birth date maybe, so ensure you put in your identity details. Secondly, then mention your heirs, all of the heirs, and the relation summary. I have 2 children, 1 son, 1 daughter, my wife, I'm survived by these, etc., etc. So write down your heirs and relation summary. Thirdly, write down in detail your property, your movable property, your immovable property. Write down in detail. When I say in detail, sometimes I see the wills that come to us for second reference. They mention that they have a bank account in so and so bank. I would suggest write down the bank account number. Write down, if possible, write down the branch details. Write down as many details as you think is valid, or as you think is making your will clear, right? in terms of immovable property, this becomes all the more important, because it might happen that some details of your immovable property might change. So ensure you write enough details about your immovable as well as movable property. Fourthly, executors and beneficiaries. List them down. Who do you want to be the executor of your will? Now, what is an executor? Firstly, executor may or may not be the beneficiary, right? Like in some cases, we see a lot of wills that come wherein people have two daughters or a daughter, and they want to ensure that their property goes, the beneficiaries of the properties become their daughters, but they don't want to maybe hassle, or maybe they think that it would probably be too much of a hassle for the daughters to go and actually execute the will. In that case, they might make son-in-law or somebody else, or their niece, nephew, anybody, as the executor. Executor is the person who will, in the unfortunate event of your death, after that, he's the person who will go and announce upon the people about your will, and then whatever was written in the will, he would actually go and ensure that it has been executed. Okay, I repeat, it may or may not be a beneficiary. And then, of course, beneficiaries are people who are ought to receive your property. Now, this could be also multiple. You can actually go into as much detail, like I have 2 flats, I have 1 car, I have a bank account, I have an FD. FD I want to give to my nephew or anybody. This I want to give to X person. This part I want to give to a Y person. You can write in detail all of this. Body. Now, this, when I said, I actually told you about the body, about the wishes, whatever it is that you want to have your property being bequeathed in, the manner in you want bequeathing happen, you can actually mention all of that in this section. You can, I would suggest, in fact, you have to, right? And lastly, attestation. Attestation is basically, writing that I'm actually writing this will without any coercion, without any undue influence. I am in my right mind. I'm doing it out of my own pure will, and then maybe endorse it, sign it. Now, who can make a will? Technically, in this room, at least, everybody. Okay. Who can make a will? The law suggests, of course, citizen of India. It has to be a citizen of India. It can be NRI, but a citizen of India. Adult. It has to be an adult above 18 years. Now, this is one section where a lot of discussion is happening. In India, the discussion is at a nascent stage. In Europe and US in particular, the discussion is going on at a full-fledged. People are saying that there was a time when you could actually build property only after you are 18 plus. So what is the point of allowing a will? But nowadays, people are building companies, properties, intellectual properties, things like goodwill, things like patents, copyrights, logos, artistic work is possibly happening before 18. So US courts are already allowing, as a special case for minors, for people below 18 to make a will. But in India, right now, it's only above 18. Okay. Thirdly, the person has to be of sound mind while making a will, which is why the medical certificate comes into picture. And lastly, you can make a will of your self-earned property. In India, you cannot make a will of property that you have inherited, ancestral property or inherited property. You cannot make a will of anything that you have not earned. Yeah, basically, your will can only be enforced on something which is yours. That's the stand law takes. A very important question: when should you make a will? Okay. I'm sorry, I added a little drama to this, but I know no better way to do it. The best time to make a will is now. What I mean is, do it as soon as possible. Do not delay, because I don't want to be getting too spiritual here, but whenever if something, God forbid, has to happen, it doesn't happen giving an intimation. It can happen anytime. Like in this case of the lady that I mentioned at the beginning of the session, right? Whenever I do this part, I feel like an insurance agent who is selling or harping on the possibility that you can die. So please excuse me for that. But yeah, make it now without any delay. That point, without any delay, I see it as a trend. People think that will is something that I need to make when I get old. Yeah, I was thinking about myths, or what are the perceptions about will. There could be a lot. There are actually a lot, but the major ones I've put on your screen. Firstly, a lot of people think that if I make a will, I will lose all right on my own property. Okay, let me tell you with authority here that nothing of this can happen. A will can and only comes into force after your death. This is the only document in law which comes into force after you're gone. Right? So there is no way that you've written a will and from the next day your heirs will say, okay, now since you've written the will, it is all mine. This doesn't happen. Okay. Secondly, heir will not take care for me or will not care for me anymore. Right? If this happens, now I can't be an authority on this, but if this happens, will itself is not the reason. Okay. In fact, logically, if anything, I mean, if the heir has such intention, he would only think that, we don't want our father, mother, or the writer of the will to change it for any reason. So I don't see why will itself could be a reason for your heir not tending to you. Okay. Thirdly, there will be a dispute already. If I write a will, I'm worried, like Ketan, you mentioned that a will is an instrument through which you can protect your family from future disputes. But if I write a will today, it will already become a point of dispute. Okay. Now, here's my answer to this. If you think that it will already become a point of dispute while you're alive, don't tell anybody. I already discussed. Will is not an agreement. There is no two parties involved in it. You don't have to necessarily tell people, even the beneficiaries, even the people who are going to get your property according to the will. It is not compulsory. It is not mandatory to even tell them. Right? So, if you think that this could be a reason, it's just a declaration. It will only come in effect after you're gone. The details of your will, don't tell anybody. Another myth, very often, what if there are more properties before I die? Now, here's my point. It's such a happy scenario to me, right? I mean, today you made a will, and few years later, you've added a few properties. It's a good problem to have. The answer is make another will. While you make a will, it's always written in the format last will. This is my last will. So if you make a will today and now 3 years later you make another will, the will that you made latest would be the one that would stand, that would be applicable, right? It's hardly. I mean, in Pune, Mumbai, all the participants, all the audience that have joined in from these cities, I'm sure any property in a city like Pune would not be less than 50-60 lakh on an average. In Mumbai, maybe twice as much, right? So if you're having a 50-60 lakh worth of a property minimum that you're making a will for, the cost of making a will itself is absolutely negligible. It's the way to look at it is, you take an insurance policy, a term insurance. Of course, you don't expect to die, but you still make it. That's for in case something worst happens, right? So maybe make another will if there is property added, nothing like it. Make another will later on, right? Another one, I'm too young for that. I've already discussed enough, I think, in this session. Nobody is too young to make a will. If you're above 18 and you have property, go ahead, make a will, right? Especially if you have children, please make a will, because will also, apart from, I'm repeating this, apart from taking care of your property, the bequeathing part of your property, it also ensures that you appoint a guardian for your minors. A very, very frequent, I've had discussion with a lot of social workers on this subject, that why is that? Initially I said the statistic is 2 or 3%, less than 2% actually, people make a will actually once in their lifetime. Why is it so? One of the things that a lot of people have said, and even I have observed, is talking about a will is kind of a taboo in our social structures. It is like people, even if I go and tell the elder ones in my family that, Dad, I think you should make a will. Somehow, this is the feedback that I've got, that people think that, oh, why are you anticipating my death? Well, it's not that. Do you think like that when you are buying an insurance policy, or somebody comes to you and say, Dad, I think you should invest money in this insurance, or in this scheme. There is X amount of growth that will happen with our funds, and also we get a life insurance. Does that mean the guy is talking about your death? No, not at all, right? So I think we as a society, it's my humble request to all of you that please talk about this subject with as many people you can. If you need my intervention, I would be more than happy to just talk and let them know, or maybe get them rid of their misconceptions. It doesn't mean that it's a taboo. It's the most educated approach. It's the most informed approach. And it's the most importantly, it is the most responsible approach to make a will, in my view. Right? So this is what I had to talk. I now will make this session open for a discussion, for question and answers. I think while there was registrations happening, there were a few questions already put up. Can somebody from the team, Hardik, Mansi, or Megha, can you read the questions? Maybe I'll first start with answering those questions. Yeah. In the meantime, if people have any questions, you can please type them in the chat box also, if you don't want to unmute and say it yourself. Yes.
So first of all, Beena Kadam asking that where to store my will so that on my passing away, it can be immediately retrieved and implemented.
Yes. Beena ma'am, the way to store your will, of course, make attested photocopies and keep it with a few people you trust. The best practice is to keep it with the executor of your will, whoever you've mentioned as the executor. You can keep the will with him. The way law suggests is that executor, after you passing away, has to, of course, looking at a reasonable time frame, has to get to your family and announce to them that there was a will made by your mother, your father, and the will is with me. The original copy is with me. I don't know if there are photocopies of it, but the original one is with me. And I have been appointed as the executor. So I'm going to read the clauses of the will to y'all. Make sure all of the people who are parties to the will and who are parties to heirship also, just make sure that everybody gets the message, and tell them, the executor tells them all the wishes that have been enlisted in the will. Okay. Sometimes if you do not, like we also work as executors of will sometimes. Like people come to us, ask us to make a will, and then they say that, could you be the executor also? So we keep a copy of the will and then we go and announce it. Executor, it's very important that you need to trust, you need to have the most amount of trust in the executor. It has to be somebody who you will, have a faith in that he would do the justice to your wishes after your death. Yeah, and the origin. So if you're doing a notarized copy, by the way, let me through this question, just let me answer this also. A notarized will is a valid will in India. It's not compulsory to register a will. However, we would recommend that if you anticipate a dispute, or if you have more than one heir, and you think that there could be a dispute, um, go and register it. Right? A notarized will, there is a higher probability of it being challenged. If it is a registered will, I mean, when I challenge, what will I say? If I am challenging your will, I will say that I don't think my mother or my father or who that person is, I don't think he has written this will. The beneficiary who is mentioned in the will, I think he has made this will through coercion, or it's a fake will, it's a sham of a will. This is the challenge generally that will go into the court. If you want to avoid such a situation, go and register it, because a registered copy will always stay with the registrar forever. And that's because there is an in-camera, there's a photograph taken and there is a thumb impression taken. So there is no way that this will can be challenged for its validity. I hope I have answered you, Bina ma'am.
Okay. So next question. Yeah. So next question asked by Asmita Jacob. And the same kind of question asked by Heda Ravi sir. Can will be made jointly with spouse? For adding any changes, is new will need to be made again? And
yes.
Same kind of question asked by Heda Ravi sir as well. Husband and wife will to be made separate or one will? Notarized or?
Okay, so husband and wife can make a joint will. Now, can make a joint will doesn't mean they have to make or they must make a joint will. In our recommendation, in my personal opinion, and also I'm sure all of the lawyers in this session would agree, that we would recommend not making a joint will. Now, what happens is, if something happens to the person who is left behind in the joint will, if his opinion change, or if his life perceptions change, if his wishes change, he cannot do anything. Okay, to give you a very, it would probably be like a classic 90s, 80s Bollywood movie example, but we have to go there. We are lawyers and our job is to worry about the worst case scenarios. I'm really sorry, I need to talk like that. But joint will is made. Just assume a husband and a wife make a joint will, and then the husband one fine day passes away. And after passing away, the heirs or the beneficiaries mentioned in the will do not tend to the wife. Now the wife looks at this and thinks, oh, her perception could change, that people valued money only. My husband and I, we were valued because we had money. Now that he's dead, and now that they know that nothing can be done, they're not tending to me. If she, let's say, wants to change the will, she cannot. Right? Secondly, other scenario, a little more practical scenario. Of course, this was practical too. This does happen. But let's say you're married, you make a joint will, one of you dies, the other one wants to remarry and does remarry later on. And then the dynamics, the equation changes. What do you do? So a joint will, more often than not, makes the person who survived stuck. So we suggest, but yeah, of course, choice is yours, but it can be done. If your question is, can I make it? Yes, it can be done. Notarization of will is must or not. It is not a must per se, but it should be notarized. At least it should be notarized, if not registered, simply because the point is, you don't want to have a dispute with your will, right? You don't want anybody to challenge. Now, if it is not notarized, what is the way to validate that this will was genuine? Right? I mean, if it is a notarized, the notary's register entries, the notary itself can be a witness to this will, or the witnesses could come and say, oh yes, we did sign in the notary's register. So all of that become evidence, right? So we suggest that notarization at least should be done, but it's not a must. Ravi sir, Asmita ma'am, I hope I've answered your question. Hardik, any other question?
Yeah. So we have some question in chat as well. Kamala ma'am asking question: if the immobile property is jointly held by the spouse, will it be essential to have a joint will rather than individual will? Same kind of question.
It would depend. You can have a joint will or you can have a separate will. I repeat myself. I always recommend a separate will. One will per individual is the way I look at it. But again, this is my opinion, and this doesn't have to be.
No, the question is especially if the property that you want to mention in the will is jointly held. Do we, divide the cost equally, or how do we go about it?
Yes. So if the property is jointly held, ma'am, even in that case, you can write what happens to your share of the property.
Oh.
Like, what will happen is, for example, if your husband and you have this as a joint property, and you bequeath your part to, let's say, for example, your son-in-law, and or your daughter who is married, and then the father bequeaths the property to the son. So after you all are gone, these two become joint owners of the property. But you can do away with your part of the property.
Okay.
Thank you. You can still make a joint will. If you make a joint will, then you don't have to worry about the part of the property. But then again, this question will still come that if you jointly want to name it for your son and daughter, then again this complication still arises.
Right.
Yes.
So Anuradha Ramesh are asking that, what about ancestral house from father?
Ancestral house from father, you cannot make a will for that. If that is your question, Radha ma'am, if you are inheriting a property, you cannot make a will for something that you have inherited. The idea is, according to law, a property which is inherited already has inheritance rights of all the heirs involved.
Okay.
So, for example, just as an example, if a person dies, he has a son, he has a wife alive when he was dead, and the son also has two children. Now, all of these people are jointly the heirs. Okay, all of them have a right.
Okay.
Now, this right has put up. The right has already become valid upon that person's death. Maybe the family was pretty good with each other, and that's why they never thought. Maybe sometimes it so commonly happens in our society that the mothers they don't involve. The children are young.
Correct.
That makes the son kind of notional head of the property, but doesn't mean he becomes the owner of the property.
Okay.
Okay.
So what about jewelry? Jewelry? Gold and jewelry?
Yes.
Silver?
Anything if you have inherited, you cannot make a will for that.
But what I have purchased it?
What you have purchased, you can make a will for that.
No, I'm asking if it has to be divided between two kids equally, then what do we do?
So you mention all of the details of your movable property, of your jewelry, all of it. Like
Okay.
this is the
Okay.
amount of silver I have, this is the quantity of gold I have, etc. And then
Okay.
if you want to say, let's say I want half of it or 50% of it to be given to my son and 50 to my daughter, just as an example,
Okay.
between two kids,
Okay.
you can mention that.
Okay.
Whenever the will comes into effect, that time whatever the valuation of that property is, that has to be split into two of them.
Yeah. Thank you, sir. Thank you.
Any other question?
Yeah, we have a question in chat. Mr. Yogesh is asking, my son is below 18 years old, but that flat ownership of 50% is given by my father to him and my mom. My mom says in that flat certificate, only my name should come and your son name we should add after 4 years, as he is 14 years. I am his guardian and I want all the wishes of my father should be respected. Please guide me on housing society's law, as my father will is registered and notarized. My brother have agreed but mom is not agreeing.
Okay. Sir, this is more complex as a problem. What I would suggest is, sir, if you can give us in the chat box, if you can just mention what time would be good time for us to connect with you, because this is more customized. We'll have to look at a lot of details. But the answer would be an answer for you. So maybe if you could just give us a time, we can connect one-to-one and then share an answer for this. But there is a reply. Don't worry. It's just that it's too big an answer, so I will give it one-to-one. Just please give your preferred timing and your contact details. We have your contact details, but your preferred timings in the chat box, and one of our teammates or me, we would get in touch with you. Any other questions, Hardik?
Yeah, so we have one more question from Cynthia Christie. So it also seems like complicated question, but still I read it for you. I have inherited my father's flat through registered will. I have 9 siblings, male and female, 4, elder to me and 4 younger to me. Since my father handed me the will, I showed to all my siblings. They asked father why they were not included. My father replied to them, he survived for 11 years after making the will. Now I want to know whether I can make a will as per my wish or not.
So your Cynthia ma'am, your father has made you the beneficiary of the will. Is that true?
Yes, yes.
Yeah, and
he's made a will solely on my name.
Okay. What you can do is, you may not be able to make a will now for this property, but
yes,
you can make a gift deed for this property. Again, to elaborate more on this, I'll connect with you once again, with you and with Cheryl also. But yeah, of course, with you I will connect, and in detailing.
He has mentioned.
Yes, ma'am.
He has mentioned all the children. And he is mentioned that he's given, and no other child
is allowed. Yes. Ma'am, I assume
and he gave them whatever response he had to give.
Okay. So ma'am, I assume you're a Catholic, right?
I am a Catholic, yeah.
So the Christian personal law applies to you in this case. And as far as I understand, in the Catholic law, in the Catholic personal law in India, a person is allowed to bequeath all of his property on one person, on anybody he wishes. It's just almost similar in this regard to Hindu law. If it was a Muslim person, then the law is a little different. Muslim person cannot bequeath all his even his cell phone property to somebody who's not an heir, not all of it. There is a prescribed limit. But in your case, he is allowed to. So I see no reason if he has made a will and if he is bequeathed all of it to you, you are the sole owner of that property. That's why I'd suggest, ma'am, the only point is you cannot make a will further for that property because you've inherited it through will. So maybe you can make a gift deed already.
But what if I want to make a gift deal for more than one person?
You can make parts of it and make a gift deed for as many people as you want.
Like what I am feeling is, since I have got my other siblings, so I want to give them some part, not them, their children, some part of the property.
Okay. Okay.
So that I wanted the legal way of how to go about it.
Yes. The best way would be, ma'am, in this case, I mean, do you want to like give everybody a share? Or do you want to give specific people in your family a share?
Specific people,
right? So in that case, ma'am, the best tool would be a gift deed. And I will, like I said, I'll get in touch with you and I will explain you as to what should be or how should be the go abouts of that gift deed. Okay. Because if you make a will such as that, definitely the rest of them, maybe they're not thinking today, but tomorrow they would think that, if somebody has got a property, then we may as well have a stake a claim, because that will by itself is not correct. And then nothing will happen. The only thing will happen is your wish would not be executed. So the best part is if you make a gift deed, it's done. Now, only thing is, the only problem between in this situation would be if you make a gift deed, that becomes applicable right now.
When I am alive?
Yes, the day you execute that gift deed. Okay, so
okay, then what about?
Sorry.
What about my rights over the flat till I am alive? If I make the gift deed now?
Yeah, so that would be jeopardized if you don't trust them. I mean, if you think that the day you do a gift deed, they will ask you to leave the house or they will snatch your rights on that flat, then I'd suggest, then we can talk in person, ma'am, as to how to go about it.
Right? Okay.
What we can do is make a gift deed to somebody, one of them who you trust fully, maybe Cheryl or somebody, anybody, and then
my daughter. My daughter.
Yeah, so we can make a gift deed favoring Cheryl, and then maybe you can write down, if you trust in her, that she would actually, honor your wishes.
Execute it later.
Yeah, honor your wishes after that, because that will would not have a legal standing, but it would probably be a document for her to know how you want it to be executed. And then you can write down and keep it with with Cheryl, that this is how you should do. And then later on, once she becomes the owner of the property, after the set date, then she can share the property according to your wishes.
Okay, understood. Thanks a lot.
Pleasure is mine, ma'am. Any other question, Hardik? Somebody in the response sheet had mentioned that today's women should be more aware of all the laws and they should know the information. I'm really glad somebody mentioned that. Yes.
It's Vaishnavi Burud.
Miss Vaishnavi. Yes. I'm really happy somebody mentions that. And I'm also really happy to tell you all that, we have a very huge proportion of women who have attended this session. And that only makes me happy. Women of today should know about the laws. In fact, we are planning to do a similar session on role of law in women empowerment on 8th of March for obvious reasons. But we keep doing this. When it comes to will, definitely, I think women traditionally have never taken the lead. They've always followed their males' leads, the father, husband, whoever. And if you think right, I'll do it. Don't. I mean, of course, I'm not talking about the trust, but I'm saying you should be knowing your rights. You should be knowing the law itself, because your wish in your property is, I think it's the most important thing. Even if generally housewives tend to think or are thought of like that this was not earned by me. This is my husband's property. What you helped build that property, right? So with due respect, it's as much yours as it was your husband's, even if he was the only earning member. So this is my take on it. I think yes, women should come ahead more and enforce their rights. That's the only way to do it. Talking about women and young, the age thing, I'm not saying something that I don't practice myself. My wife is all of 36 right now. Last year, I think last year, when we were 34, we actually went ahead and registered a will ourselves. She made her own independent will also, not a joint will, an independent will of her properties. I think it's a very healthy practice. We are not expecting that we die, but and yeah.
Yep. Can I ask one question, please?
Yes, sir. Yes.
This is Mehra from
yes.
Pune.
Yes,
whether executor can be, one son-in-law or two son-in-laws.
Executors can be one. Executors can be one son-in-law or two son-in-laws.
Okay, they are not beneficiaries. They are not beneficiaries.
If they are not beneficiaries, is no problem, sir.
No problem. Now, about the notarization, you told rightly that it is not must, but whether doctor's approval will be suffice or not.
Sir, doctor's approval is just a declaration of the fact that you're sound mind. Okay, but what about things like did you write the will in coercion or undue influence, or did you write the will at all? If such disputes come, then there is a problem. So doctor's certificate is no testament to the will itself.
Okay.
It's like how do I say? I mean, if you have an Aadhaar card or if you have a driving license would probably be a good example. If you have a driving license, but let's say for 20 years you haven't driven, all of a sudden today you feel uncomfortable. Now you have a driving license, but that doesn't mean you can drive. So that itself doesn't protect you from any wrong happenings on your account. If you were to take a car and dash it to somebody, you can't say that I have a license. No, I can't be incriminated. Of course you can be incriminated, right? So it is a similar thing. I mean, if you have a doctor's certificate, that itself doesn't testify the will.
No, sir. Doctor's approval on the will itself, you mean to say, along with the registered number, MBBS doctor, practicing doctor.
Yes, sir.
That has to be, signed, I may say, and along with the two witnesses, then notarization should be there, you mean to say.
Yes. Even while doing the notarization, of course, you have to go to a doctor. Firstly, the notary will not execute notarize your will unless he sees the certificate from a registered practitioner.
But he will attest. He will attest on the paper itself.
Yeah, he will attest on the medical certificate itself. Yes.
Not medical certificate, sir, on the will itself.
The doctor, you're saying?
Because, yeah, in our building, people are making, a draft of the will and, signing, then two witnesses, and then doctor's approval.
Yes.
Separate certificate is not required for that.
Yeah. So
at the end, it is being written that the will is made by Mr. Mehra, he is sound health and all these things. Then he signs and signs.
Yes, sir. So during the session, I was saying that, with regards to will, there is no standard format.
Yes.
There is no one right format. So your method
Correct.
is as long as there is an attestation from a registered medical practitioner with a stamp,
Yeah.
it's valid. If you mention it on the
Wow.
will itself and there is sign.
Great, sir. Great. Thank you very much. Thank you. Thank you very much. Mr. Ketan?
Yes. Thank you, sir.
Thank you. God bless you.
Any other question in the chat box? Hardik, can you see?
Yeah.
We should have a session again, gentlemen. So session in future also, please organize.
Surely, sir. Surely, we'll keep doing this. In fact, we are overwhelmed at the response that we've got. We've got people from Nagpur, Pune, Mumbai.
Yep.
And then there is a lot of questions. There's a lot of interaction. So it suggests. So we're definitely going to continue this. In fact,
do you have your office in Pune?
Yes, so we have two offices in Pune. One is in Dhanori and one is in Dighi.
Where? Second one?
Dighi.
Dighi. Oh,
I'm in
Hadapsar. I'm in Hadapsar near Amanoramov.
So you don't have to necessarily come down to our office. If you have any kind of query or anything that you need our help in, please reach out to us. So one of us will come down to your office.
Okay, sir. Thank you. Thank you very much.
Yes.
Thank you.
Hi, Ketan.
Hello.
This is Tejal here.
Hey, Tejal. Hi.
Hi. See, I have a query. Now, since you know about my husband's sad demise,
yes,
and he has some ancestral property, okay, which I'm not completely aware of how much and where exactly and all. I mean, I have a little bit idea about it. Now the thing is, this property is, I think this property is belonging to my mother-in-law and two sister-in-laws. Okay, even my husband's name was there, but then for obvious reasons, I think his name will be now deducted, and then my and Parth, my son's name, will be added. But then as of now, none of the action has been taken in this regard. So is there any way that, I don't ask for property, but then at least I'll be on a safer side? I know that, okay, this is the part of property that is going to be given to me as a property right to my son.
Yes.
So, I don't have to ask for it, and it becomes a quite obvious thing for them to allot.
Yes. So, like I said, Tejal, I'm going to conduct a session, another one, specifically about inheritance and the laws related to succession inheritance in case someone dies without making a will. So I'm going to cover more on that, and I'll invite you for that session. But just to give you an answer, you can be very sure that yours and your son's rights are already in place.
Yeah, but then how would government know? But that my husband has.
I'll tell you. You may not be able to. You may not be able to sell it right away. But if the property has been put out for sale by somebody, you can definitely at that time object to it. If family situation is not so good, if the family situation is very comfortable, you can actually, in a more matured way, intervene and tell them that, can we go ahead and do a partition deed, or can we somehow ensure that, my son's right is actually technically claimed on it. If the situation is good, I mean, if there is such level of comfort between.
Situation is good. Nothing has been wrong till now. That's why I'm just asking that, even though I didn't ask for it, but then they should, I due to some or other tactic, I'll be obviously be on a safer side that, okay, this is going to happen. So you are saying that now when my husband's name was there, even if they try to sell it, the registrar would ask what is happening to this person then. Where is he? So if he is not no more, so who are their highest, right?
Yes. Yes. So the
In
moment
that
that
case, we come
property,
into picture.
yeah, the moment that property is going to be sold, whoever's name is on the property's papers, they will say, where is the person? Of course, he's dead. Okay. So the second most question the registrar will ask is, do you have a succession certificate? Okay. Now,
Whose succession certificate?
that person's whose name is on the property. Could it be your father-in-law, I think, or his
My father-in-law passed away long back. After
No,
that, the entire property.
whoever's name is on the property right now,
Okay.
the papers, his succession certificate. If that person is not alive, his succession certificate will be asked for. And the moment there is a succession certificate asked, all the heirs are supposed to sign that or object to it. If you're worried that somebody goes and signs, applies for a succession certificate without including you or your son, right, there will be a paper notice. There will be, you will have to be that much aware, right? And you can go and object. Even if, God forbid, such a sale happens with some not so good practices, you can any day, your claim will never go. It's just that how much more difficult you want it to make. A lot of people, I want to, with Tejal's answer, I want to answer everybody about one thing. A lot of people think, I didn't cover this in the myth. A lot of people think, I have only one son or I have only one child. Why should I make a will? Automatically it becomes his or hers. There is nothing automatic in law. Please let me tell you. Even if it is your only son, if you have died intestate without making a will, that only son would still have to go to the court to get a succession certificate. Okay, because after your death, how does the court know that he is the only heir? That is the point of the succession certificate. Are you getting my point?
Do you have any idea where do you get the succession certificate?
We can help you with that. Our team can help you with that.
Oh, really? Okay.
Yes.
Okay.
So Hardik or me,
I think I can connect to you after the session then.
Yes. Or we can talk also.
Sure.
Firstly, I'll have to look at a lot of things and then we can take that process ahead.
Sure.
Right? Okay. I have a question that Mr. Sanjay asked that my father made a will in 2004. 2 witnesses has only signature and no name while another's address is not there. Is it treated as valid? Please advise. If it is a notarized will or a registered will, it is treated as valid. If the same person has made a notary a registry as a witness in the notary's register also, or in the registrar office also. Okay. If it is a will which is not notarized, then this will be very difficult to prove that they were witnesses. Also, sometimes there was one question prior to the session. We said, what if one of the witness is dead? Does that render the will invalid? No, it doesn't. It doesn't render the will invalid. The witness has to be a witness while you register the will, not while the will is executed. Right? It can very well happen that, right? If you tomorrow, if somebody has put me up as a witness and by the time he is dead, before that I'm dead, it could very well happen. Doesn't make the will invalid. I am a witness to the fact that the will was registered on that day. That is the witness job. Okay. Neeru has said that she missed the story of that lady. I'll just, in a nutshell, tell the story again. There were quite a few people who joined in late. The whole purpose, the whole objective of putting this session online today was that earlier this week, there was a lady who came to our office. She was in financial distress. She had come earlier too. And finally, she wanted to sell her flat. She got a buyer. And when she gave the papers for us to make the sale deed for her, we saw that it was in her husband's name, the property. And the husband died of COVID, unfortunately. And there was no will. Now, firstly, there will be a succession certificate needed, which makes the matter very complicated because that succession certificate itself takes 6 months, 7 months at least, why will the buyer wait for that long? Of course, right? So now imagine a situation where you are in distress. You finally got a way, you got a buyer in this market. He is willing, all of this is done. And now for one, I would say, with due respect, a ridiculous thing such as this, all of this has to wait. She had a son. I felt something in me moved that day, that wow, this is not what we deserve as human beings, as good people that we are. So I thought probably a lot of people lack awareness about a will, and also a lot of people think I'm young, why should I make a will? That's how this session originated in my own head. So that was the story, Niruma. One question I've received is, and this is a very important question, I'm really glad somebody asked this. I have nomination declared on my bank accounts and other properties. Would I still need a will? Now, this is very, very important, ladies and gentlemen. Nomination is not transferring or bequeathing your rights. When you put up a nomination in a bank account, you are entitling a person to receive your property from those banks or wherever else, from the authorities. He's just a receiver. Okay. If, let's say, you have 2 children, if you make one of them as nominee let's say in your FD or for your locker, that person, that son or daughter, that child can go to the bank and say, I am the nominee, I need the money. He will get the money. Doesn't mean he will keep the money, or he doesn't have to share with all of the heirs. So if you sign up nominations, but if you die without making a will, your property is still considered as intestate property. This is very important, people. I think I'm going to edit my slides and add this as a myth itself. Okay. There is no way that this property would not be, there is no way that this would be treated as you're the beneficiary of that property. Your job is to receive and then share according to the succession laws, the inheritance laws, right? So if there is a nomination, don't just rely on that. That's a good thing, but ensure that you have a will. How to sell a property which I received from my mother through registered will. This property was self-earned by my mother. Very simple. You go to the registrar to sell while you're registering the sale deed. You give your details, you give your property details, and then you give the registered will copy to the registrar, attach it with the documents. That will, since it's a registered will, the registrar might want to double check it in the system with the registration number. He sees that you are the beneficiary of that will, and you can go ahead. Sometimes, especially not in your case, but especially if the will is not registered, if it is notarized or not even notarized, in those cases, then the registrar would say, go and get a probate. Now, probate is a document that is necessarily given by the courts, and probate is validation of a will. Okay, so if you have written a will which is not registered, it simply means that the court will now check for the authenticity of the will. But the probate itself can also take some time and some money. Okay. But in your case, ma'am, Megha, who has asked this question, in this case, since your property is transferred or is descended upon you through a registered will of your mother, and it was her self-earned property, there is no problem at all. Any other questions? Have I missed something?
We have one more question. Can minor make a will in case some parents lost their lives?
Yes, I discussed it in the session also. A minor in India, anybody below 18 cannot make a will as of now. But there is a huge discussion happening in US already. The courts are allowing in special cases because 13, 14-year kids are coming up with fantabulous products, intellectual property, copyrights, patents, new technologies, or something like that. They're writing books, some of them. So basically they are earning and they're building properties, intangible properties, or tangible also. So in such special cases, US courts have started allowing it. In India, it's still not happening, but the discussion is definitely on the way. But as of today, minors cannot make a will.
There is one more question, sir. Can my husband make a will without my knowledge?
Okay. Can your husband make a will without your knowledge? If you want a short answer, yes. He can. If it's a self-earned property that he's making a will for, he can. I discussed it in the session. A will is a declaration. And a will comes into effect after your death. So while you're alive, you're not bound to, technically, legally, you're not bound to tell anybody about the will. Except, of course, for the witnesses who are going to come and be the witness, or the executor if you're going to keep the will with somebody else. But you're not bound to tell the will. So your husband can, legally, strictly legally speaking, he can make a will without your knowledge. That's his right.
Another question from them. Can a family member be a witness to a will?
Can a family member be a witness to a will? If he is not a beneficiary, he can be a witness to the will. If he is not a beneficiary of the will, or if he is not directly an heir, he can be a witness to the will. Beneficiaries cannot and should not be a witness to the will. I mean, what is the point? I mean, tomorrow, if the will is challenged and it comes out that I am the beneficiary of the will and I was itself the witness, it's not correct. So yeah, should not be.
Okay. So one of our clients asked Nilesh Pawar. Hello.
Yeah, tell me. Yeah, you are audible.
Yeah. So one of our client Nilesh Pawar asked that how can I favor my property to my minor child?
The best way is to write a will. Okay. And in the will, you can mention that my child, who is a minor right now, until he attains the age of 18, such and such person will be the guardian. And you can also write what can the guardian do and what can he not do. And once he attains adulthood, then my child becomes the whole and sole owner of my property, or whatever the percentage that you want to allocate.
Thanks.
Is there any other question? Okay. So if there is any other question, we have communicated with all of you, I'm very sure. So you know where to reach us. Our mobile numbers, our Facebook account, we are just a call away. Most of you know our office address. Also, you can drop down anytime. We can reach to you anytime. You don't necessarily have to. In fact, we as a company, we also make notarized wills at your residence. You don't have to. We have tie-ups with notaries. If there is a special case, we can get the notary to your place also. So we not just with wills, with other legal issues also. If you ever feel that there is something that we could be of help to you, please get in touch with us. This is our social media presence. And Like I said, you all have our mobile numbers. So yeah, that's it. I really want to thank all of you, my team. Really a big thank you for putting this up together. There's a huge time difference. I gave them very little time because it was actually like a whim or a fancy that came to my mind because of that story. Late in the night, everybody, we're doing this on Saturday, and they did not go away from it. Yeah, so thank you to my team, and thank you to everybody who took time out on this weekend and attended this session. Like I said, please get in touch with us if we could be of any help. Thank you so much.
Thank you, sir.
Thank you, Ketan. It was a lovely session.
Thanks, Tejal. Thanks, Tejal, for being there. We are going to get in touch and discuss about your topic.
Sure. As per your time. Today, tomorrow, no problem.
Maybe tomorrow?
Yeah, sure. No problem.
All right.
Thanks. Bye.
Do leave in a feedback if you all can. It would probably help our cause. It would help our team to. It encourages us that much more. And of course, we're going to write to you about our new sessions, about our new plans. So, yeah, thank you once again, everybody.